Story time. Wanted to talk about a hearing that I was not involved in this morning, but that I overheard while I was in court on something unrelated. There was a person there who was a pro se litigant without a lawyer, and he had filed a petition, and he had emailed this petition to the other party and her lawyer. And he had then thereafter filed a motion for default when the other party didn't file an answer, and the judge granted the default. Well, now the other party's attorney is there asking for the court to set aside the default, and that was granted. The reason being that you cannot serve someone via email unless they have filed a designation of email address and authorized you to serve them via email. This is a little bit different if you're serving an attorney, but the attorney has to agree to accept service and file an acceptance of service. So if you are operating without a lawyer, you cannot just email someone your petition and think you've served them properly. Stay tuned for part 2. So part 2, what does this mean that the default's getting set aside? Well, basically, if you have a default, then the case is ready to be finalized, because a default in essence is saying that the other person is agreeing to what you've requested in the petition. So when the judge sets aside the default, well, now you're kind of back to the beginning again, and you wasted a lot of time if you've been waiting around thinking you have a default and you don't really. So now the other person really does have to be served, and you've got to go through all of the steps that are required in a case. So it was a giant 6 months waste of time for this guy. Also, the guy asked, so judge, now do I have to serve them by the sheriff's office? And the judge sort of halfway responded, it's not really the judge's job to inform him or educate him on the proper way to do things. But the sheriff's office only has to serve people in domestic violence cases. Otherwise, you can serve someone through a process server. But in domestic violence cases, it has to be done through the sheriff. Part 4, service can be effectuated, like we've already talked about, through a process server, through the sheriff's office, through a designation of email and an acceptance of service. And finally, you can effectuate service through publication in a lot of cases, but this is only for instances where you absolutely cannot find the other person. You're going to have to do an affidavit of diligent search. The publication process is a real pain in the ass, but it is effective in terms of what the court needs to see. It's not very effective, super antiquated and outdated for actually making the other person aware that the court case is going on. Service by publication, after you've done your diligent search, then you're going to get paperwork from the court. This is going to get filed and published in a newspaper for a period of time, and then after that, you're going to be able to claim that you've effectively served through publication. If you like